Hi, I'm Matt Faulkner, and I'm sitting here with Jeremy Swanson, and we're discussing some various topics in family law and litigation. And one of the topics that come up in family litigation is emergency custody orders. What is that?
Emergency custody order is a situation where the child is in danger, and when you have to ask for emergency orders some kind. There's various reasons that you can have for that, but it has to be a fairly serious situation to ask for them.
What kind of circumstances are we talking about here?
There are a lot of different ones, and some of the most common ones are alcohol or drug abuse by one parent, a arrest for DUI, domestic violence, things of that nature. If you have serious neglect or injury to a child, failure to care for a child resulting in injury, those are the kinds of things that can result in an emergency order. In extreme circumstances, unsafe living conditions can also be an issue that's concerning enough for the judge to make temporary orders. Okay,
it seems like a pretty serious threshold. Are there other kinds of activity that the court may say, well, it's not that serious or serious enough to require an emergency? Because it sounds like a pretty extreme measure.
It is. It's a fairly quick custody change within a couple of days. So things that do not qualify that people sometimes try to file for, one is emotional abuse. Unless it's very serious, the judge will not make a change based on emotional abuse. Also things like missing school, bad grades, or simply the unhappiness of a child with how the visitation is currently set up are all going to be considered not serious enough to have emergency orders. Not that the judge will not address them, look into them, and make a ruling on them eventually, but they're not considered a true emergency. The same thing with conflicts over visitation orders, interpretations of orders, or even, except for in very extreme situations, a holiday visitation. Those things the judge will have a full hearing on and issue orders, but not on an emergency basis.
Okay. So the court's really looking at, okay, is this something that needs to be addressed like immediately?
Correct. Right? It's something that there will be an immediate harm that can't ever be fixed if the court doesn't interfere now. And again, the safety of a child is a big issue. The mandate of the court is to act in the best interest of the child. And while they always take time to hear all the evidence and determine what is the best situation, there are some times when really quick action is necessary. And if you have a situation that reaches to that level, the court will act on an ex parte basis. The other thing to keep in mind is that if it's the kind of danger where you feel you're in physical danger, which often comes up in domestic violence situations or situations where somebody is acting erratically or aggressively, sometimes under the influence of drugs, then at that point you need to contact law enforcement. There's not much a family law judge can do for you if you're truly in danger, and if it reaches the level of physical violence either against you or against a child, then law enforcement needs to be contacted immediately.
Yeah, so if you have an emergency, call 911.
That's right. The court will get,
yeah, okay, I'm sorry.
Even in an emergency situation, the court will get back to you in a couple of days, and law enforcement comes out now. So protect yourself, protect your family.
Okay, well, thank you, Jeremy.